Hello and welcome to the open platform of Public TV of Armenia. Today I will discuss the order of United Nations International Court of Justice on the request for the indication of provisional measures in the case of Armenia versus Azerbaijan. I am honored to host Mr. Yeghishe Kirakosyan, who is the representative of Armenia before the European Court of Human Rights and the agent of Armenia before the International Court of Justice. Mr. Kirakosyan, thank you very much for your time.
Thank you.
So what are these provisional measures and what is the order by the UN court about?
Armenia, of course, Armenia applied to the UN court or the International Court of Justice back in September 16 by filing an application for instituting proceedings based on the Convention on the Elimination of All Forms of Racial Discrimination. And Armenia, along with the application of instituting proceedings at the court, also submitted a request for application of provisional measures under the same convention. The case brought by Armenia against Azerbaijan is predominantly relating to grave violations and systematic violations of the Convention on Elimination of All Forms of Racial Discrimination by Azerbaijan over the past decades. And based on that premise, Armenia also has requested some provisional measures to be applied to Azerbaijan in lieu of securing and guaranteeing the protection of some certain values protected by the Convention and Convention rights that are under the imminent threat of producing irreparable harm if violated by Azerbaijan. And the court actually ordered Azerbaijan to comply with certain provisions of Azerbaijan, and the court actually considered that there is rights, some of the rights for which Armenia asks or seeks provisional measures are plausible, and there is also an urgency and there is a risk of irreparable harm to be caused, and ordered Azerbaijan to one of the measures related to the treatment of the captives and the POWs in line with the requirements of the convention. And there is also another measure which relates to the protection of cultural heritage and religious sites, Armenian cultural heritage and religious sites, and from destruction, from vandalism, and holding accountable of those who commit such acts. And we also have a provisional measure, which is a central one, I would say, which is the prohibition and prevention of any hate speech and hate propaganda against ethnic Armenians, including by high-ranking state officials and state institutions of Azerbaijan. We also, the court also ordered not to take any measures or not to take any steps by Azerbaijan, which could aggravate this dispute furthermore. So this is in a nutshell, this is what the court ordered to comply with.
So can we say that the court acknowledged the problems that Armenia applied for by issuing these orders for provisional measures? Can we?
Of course we can. Of course we can. At this stage this is a very early stage in the proceedings before the court. At this early stage, Armenia presented ample of evidence to the court to show that certain rights which are plausible under the convention, that's the wording of the court that it uses, and a violation of which could produce irreparable harm or irreparable prejudice, which is an element required for the application of provisional measures by the court. And of course, based on that evidence, based on the legal argumentation presented by Armenia during the oral hearings in October, the court considered that there is this urgency to order Azerbaijan to comply with certain measures. The court actually considered there is a problem. Of course, there is a risk that an irreparable harm and prejudice could be caused under the certain rights or violation of the rights by Azerbaijan. Thus, the court ordered Azerbaijan to comply with such measures in order to prevent such irreparable harm from happening, which is a cornerstone and which is a very a necessary precondition for the court to continue with the examination of the case further.
I know that there is a main case of Azerbaijan versus Armenia versus Azerbaijan. How are these provisional measures connected with this main case, which is either under the preparation or
Sure.
already prepared and to be presented to the Court of Justice?
The case is this is as I said in the beginning, this is just the start of the proceedings, and the court will assign certain time limits for the further procedures to be followed, meaning that still Armenia have to submit a lengthy memorial, written memorial, along with the exhibits and evidence materials annexed to that memorial, which are providing more in-depth analysis of the violations by Azerbaijan. And the core, of course, that application has already been presented in the initial application for the institution of the proceedings before the court, which was submitted in September 2021. And that relates to, of course, the decades-long anti-Armenian hate propaganda and animosity propaganda through different channels, including the high-ranking state officials, state institutions, through different means, not only the hate speech, but also the educational materials, through upbringing of children in kindergartens and different methods of use to create a generation which is propelled with animosity towards ethnic Armenians. And of course, another cornerstone which has also been recognized by the court is the vandalization, destruction, and alteration or falsification of Armenian monuments, Armenian culture monuments, religious sites, churches, cathedrals, which is a routine practice instituted by Azerbaijan as a part of the anti-Armenian propaganda to erase anything and everything that is Armenia on their territories. I mean, by destructing cultural monuments, by destructing religious sites, by altering the origin, or falsifying, presenting as if those cultural heritage sites or religious sites are belonging to other groups like Albanians or Udi groups. So yeah, those are the main. And then of course there's lots of individual rights that are guaranteed under the convention, which are being violated by Azerbaijani policies, which should be considered in the merits of the case.
Mm-hmm. The Foreign Ministry of Armenia issued a statement afterward when the Court of Justice issued the provisional measures, which says, quote, Armenia will consistently pursue Azerbaijan's compliance with the court's orders and will inform the court of any violation, end of quote. If Azerbaijan does not comply with the court's order, which is quite possible, what the process is provided? What is the next? By this order, it is important to underline by receiving this order, the process is not like concluded or finished. Like it is the opening of this process. More, I would say, it means that Armenia is indeed going to follow closely what Azerbaijan's conduct is in line in the context of the order issued by the court. And of course, if it deems necessary, Armenia will notify any of the violations of the order by Azerbaijan that can be or will be in the future. Hopefully they will not, but if there are any, Armenia will notify the court first of all about any developments and that are tending to violate the court's order. And of course, there is also a measure applied by the court that parties to the case should refrain from taking any action that would aggravate the dispute any further. And that means that this is a quite broad statement, and I think it also includes the escalations that we monitoring across the Armenian-Azerbaijani border that can also be a subject of that notification to the court.
and also any other development that are going against the purpose and object of the Convention on Elimination of All Forms of Racial Discrimination. We'll notify the court about those developments, of course, but there is also the mechanism under the statute of the court and the UN Charter, which is the Security Council, which is the main political body of the UN, and it is also has the competence of overseeing the implementation of the decisions of the court, including the orders and the judgments. And of course, if needed, Armenia should also use this possibility of notifying or raising this issue before the Security Council to ensure the compliance by Azerbaijan by the orders of the court.
Mm-hmm. So what are your expectations from the further process of the main case, and when can we expect the decisions or the orders related to the main case of Armenia versus Azerbaijan?
The timeline of the case will be more. We're still waiting for the court to assign a timeline, to see what the timeline would be. But I think we'll have more clarity in a month or so. What's the timeline of the case will be after we have the necessary discussions with the court, and based on that, we'll have more clear understanding about the timeline. But in a nutshell, or if we have more general observations on that, I think the consideration of the case, if we are taking into account the merits consideration of the case, that can take many years. That can take up to 5 or even more years until we reach the end of the final judgment in the case. And I cannot at this point point out, of course, the expectations of Armenia are that we need Azerbaijan to be held accountable for the long-standing and systematic violations by Azerbaijan of the Convention on Elimination of All Forms of Racial Discrimination, which unfortunately continue as we speak. And this accountability should not only involve the cessation of these violations, but also redress. I mean, in case if that's possible, through restitutions, restoring some situations which existed prior to the violations, if that's possible. And of course, we also expect compensation to be awarded to Armenia. And of course, that's a very long run. I'm telling you, that's the end of the case. But I think that's the expectations that Armenia has when bringing such case. But I think that's all of it.
And that needs a very serious preparation on grounds.
Of course, that needs, and which started actually, and where Armenia is very seriously approaching this exercise. And of course, as you have seen also throughout the hearings on the provisional measures which took place in October, the team that Armenia put together is quite an impressive
very
team.
Professional experts and high professionals, especially when presenting the evidence about the violations by Azerbaijan. Coming to the European Court of Human Rights, what do we have in this court related to the cases brought by Armenia against Azerbaijan?
In the court, in the European Court of Human Rights, we do have also pending proceedings against Azerbaijan. We have, of course, the interstate proceedings, Armenia versus Azerbaijan. The interstate application by Armenia was submitted in early 2021, on February 1st. And that's the application encompasses basically the violations that took place during the war of 2020 and in the aftermath of the war and the armed conflict that relate to not only to the victims of the war, meaning that the civilians targeted and killed throughout the hostilities, but also it encompasses the POWs and captives and captured persons and civilian captives, torture, inhuman treatments, and executions and targeted killings. But also it encompasses the property rights, of course, of tens of thousands of Armenian compatriots who were residing in the territories of Republic of Artsakh and were forced to flee because of the war, because of the systematic shelling and bombing and targeted attacks, and that also involves many other rights that are guaranteed under the European Convention on Human Rights, that including right to education, for example, and the right to private life and family life, and many other, right to freedom of speech, by the way, which includes also the journalists who were exercising their professional duties throughout the conflict, who have been targeted throughout the conflict. Several times, and that's also a part of the application. And this is as you can see, it's a quite extensive and voluminous application that has been presented by Azerbaijan, by Armenia against Azerbaijan. And we also have several measures that have been presented to the court in relation to Armenian captives. As you know already, there are numerous interim measure decisions applied by the court with regard to Armenian captives, starting from back in October of 2020, and we also have applied for the recent captives. We have a decision, partial granting by the court of the interim measure, and indicating Azerbaijan to comply with that measure and provide information with a deadline about the captives that Azerbaijan holds now. And of course, we also raised the issues of the sham trials that were taking place in Baku with regard to Armenian captives, those state trial proceedings, which are violating all the guarantees of the European Convention of Human Rights, specifically Article 6 of the Convention. So this is quite an extensive process that we are experiencing there too. And currently, the case is relinquished to the Grand Chamber of the court. The Grand Chamber is going to consider. So at this stage, we are in a stage of the written proceedings, meaning that we're waiting until Azerbaijan provides written response to our application. And of course, we're also preparing our response and observations with regard to the application of Azerbaijan filed against Armenia. And after which, we'll move to oral hearings in the case, which we'll think might happen next year, maybe.
Mr. Kirakosyan, thank you very much for joining us.
Thank you very much for the invite.
This is Open Platform of Public Television of Armenia, and today I discussed the order of United Nations International Court of Justice on the request for the indication of provisional measures in the case Armenia versus Azerbaijan. I hosted Mr. Yeghishe Kirakosyan, representative of Armenia before the European Court of Human Rights and the agent of Armenia before the International Court of Justice. Thank you for watching.